Hi, I'm Rashawn 11 with Keller Williams Realty. So today I want to go over the G car sales contract. So if you are purchasing in DC or Montgomery County, this is the contract that you will use. So this sales contract is made on, that's the date of the offer between the buyer, that would be your name. If you're buying with someone else, their name would be next to yours or vice versa, before or after. And the seller, so is the seller husband and wife? So whoever owns the house will be here, whether it's an LLC, corporation, whether it's a bank, that information will be there, whoever's selling the property. The listing company, that's the agent that is representing the seller, and the buyer's agent if you choose to hire me. The selling company would be Keller Williams would be there if you choose to hire me, and the represents the buyer box will be checked as well. So paragraph. So when I talk about contract terms, so I will talk about paragraph. So paragraph 1, real property. And then when I move on, I'll talk about paragraph and move on to the next item. So buyer will buy and seller will sell for the sales price. Seller's entire interest in real estate, real property. Sorry, I said real property. Real property is real estate, with all improvements, right, and appurtenances described as follows. So that's the street address. If it's a condo, even if it's not a condo, it might have a unit number there. City, state, and zip code. If it's in a condominium, that will be listed there, or project name if it's a cooperative. Parking spaces. What are the parking spaces? Is it a storage unit? What are the unit numbers? What's the legal description? Is there a lot? Most of the time, or pretty much all the time, it's going to be a lot number. It might not have a block or square or a section. So if it's there, I'll put it. If it's not there, then you can't put what's not there. Subdivision, where is it actually located? What's the tax account number? That will go there. And paragraph 2, the jurisdictional addendum. So is this property in DC? So that box will be checked. Is it in Montgomery County? That box will be checked. So down payment, are you using a down payment program? Even if you're not, you have to state what type of financing that you're going to do. If you're not going to do, if the program you have is 100% financing, then that will be 0. And your first trust will be 100%. If it's not 100%, then that percentage will change, and we can talk about that later. And if you're doing a second trust, so it's an option for you to do a 80-20 or 80-10-10 and put down 10%. So if it's a second trust there, then that box will be checked on under line B, financing, line 2. And seller held trust, I've never dealt with that in all my years, but it's there because it's possible. And total financing, so that total percentage is there, and then sales price, what are you willing to pay for the home. So paragraph C of section price and financing. What type of financing are you doing? You're obtaining something. You're usually not assuming the loan. So it'll be box, the first box, obtain, and then the third box will be fixed. Right now, people aren't really doing adjustable rates, but whatever type of financing you're doing, you have to state that with your initial offer. Is it a conventional loan? Is it an FHA loan? Is it a VA loan? With this educational process, it would be first box will be checked, would be conventional. So if this contract was not a contingent upon financing, then that box will be checked, and other would be what other type of is it contingent on a special particular program, that would be there. And so the second trust, and you have to state what is that an adjustable rate, is it fixed rate, are you assuming that, which you wouldn't assume a second, but it is there. So, and it talks about assumptions. So paragraph 4 is talking about your deposit. So what is that? That is your earnest money deposit. So buyer's deposit in the amount of, what is that amount, shall be held by the escrow agent. And have you delivered it or have you not delivered it? So you have to state that. So also we would have an escrow agreement to say that the item was actually, the money was actually received. So that's the amount that will be credited towards your sales price at settlement. Not sales your expenses. So funds due at settlement. So that's the balance of funds due at settlement by the buyer or seller will be paid on or before the settlement date. It's going to be either wired, or you have to get a certified check. Paragraph 6 is settlements. So the settlements, the buyer and seller will perform in accordance with the terms of this contract on a settlement date. So it could be on or before. So if you say, October 1st is the closing date, so it's on or before. So if the lender and everybody agrees that it can settle before then, it can happen. But a lot of times you'll need an extension, so you have to do that ahead of time. So preferably before a settlement date. I mean, you would know that you're not going to close on time. It shouldn't take you till, the date of settlement to not know that you're not closing. You would know that at least 4 days ahead of time that it's not gonna happen, which I would know that ahead of time too also. So buyer selects whatever the title company is, and based on the program that you choose, you might have to choose from a selected list. So we can talk about that. So property maintenance and condition. So this is typically, it doesn't really matter which box you check. So it could be the date of offer, date of home inspection. I usually typically check date of home inspection because we've seen it with the showing. So that's the date of offer. But the date of the inspection, that's the date really that you need to use because that's the date that you've last seen it. So also, this is the section, so the property is contingent upon home inspection and other inspections. And if most of the time you wouldn't decline the opportunity for an inspection. So the first box will always be checked. So access to the property, you'll have access to the property, but limited. I mean, you can't just keep going in the house. So paragraph 10 is a home warranty. Are you going to get a home warranty? It's not something that you have to put in the contract if you're not going to ask the seller to do it. So it's not like even if you put it in the contract stating that you're going to purchase it, you don't have to purchase it just because it's in the contract, because you may change your mind. But if the seller is paying for it, then they do have to do it. Does that make sense? So representations, are you intending to use this property as your primary residence? So if you are, the first box will be checked. If you're not, then it's not your primary residence. And that could be a deal breaker for your loan, because if it's supposed to be your primary residence and you check the second box, it will not, then they're not going to give you the loan because that would be considered an investor loan. And not saying that you couldn't get it, but based on the type of financing you're choosing, that might be an issue. So moving on. So wood destroying insects. So this is stating that it should be at the buyer's expense unless you're doing VA financing. The seller has to pay. Lead-based paint disclosures. If the property was built before 1978, the seller has to disclose those items to you. So you would initial that, and it will be a separate addendum. So financing application, you have to apply for submit an actual application. Now you have submitted your pre-approval, but that is not basically getting so once you actually find the property and you're under contract, you have to submit the package to the lender, which I would do that for you. But you have to work with the lender to actually start the process. So that's technically the financing part that you haven't done, even though you may have submitted an application before, but you actually have to, for it to be considered real, you have to have a property. So that's, in a nutshell, that's what that is. So paragraph 15, this is basically stating, any risk of damage, loss of property by fire, act of God, or any other casualty. So basically, you're not responsible for the house until it's your house. So if something happens to the house before settlement, it's up to the seller to fix it and deliver it to you based on how it was when you saw it. Title, the seller has to provide clear title to you, and it has to be free of any liens or encumbrances, because the lender won't lend money to you if there were liens or any issues on title, which they call those clouds of title. And there's a whole paragraph on that. So possession, you're going to possess the house when you actually close. Any fees will be prorated, any adjustments, any disputes. There's a whole paragraph on that. Legal expenses, that's if there was a dispute or a breach of contract, I can't even talk. So misrepresentations. Anything that had a dispute would would have to go to court, basically. You have to perform based on the contract. The seller has certain responsibilities, so they are supposed to still keep their mortgage paid. They don't need to be in default because that could change things. They need to not be in violation of things also. And paragraph 25 talks about default. So that's a whole big paragraph on that. And disclosures to the parties, property condition, legal requirements, financing, broker, property taxes, property insurance, title insurance. This talks about FIRPTA, so this is for a foreign investment. So basically, if the property owner was a foreign entity or person, then there has to be a certain percentage that's held. And if it's not held, then it would be your responsibility to pay for it. So it's important that we know that the person is not a foreign person. So days are considered calendar days unless otherwise specified. So business days, whenever used, means Monday through Friday, excluding federal holidays. For purposes of computing time periods, the first day will be the day following delivery, and the time period will end at 6 p.m. on the day specified. So notices and delivery, those items will be in there. Void contracts, entire agreement. This contract will be binding upon the parties and each of their representative heirs, executors, administrators, successors, and permitted assigns. So you would sign at the bottom. So this section, so it says date of ratification. So this is once I submit the offer to the seller. So all of these items we would discuss and then you would sign. You don't have to worry about where to sign because the DocuSign will tell you. But one item that will not be filled out is the date of ratification, because I can't send them the contract and have a date in there because the seller has not said, okay, well, I'm willing to accept everything you said. So it's whoever is the last person that has agreed on the item puts the date there. So on the left-hand side, that's your side. So that would be your address, your email address, your telephone number, and then selling company's name. That's the real estate, that's the buyer's agent company. And my name would go there and all of that. So now the next part. So based on the financing you do, that the next item will be the type of financing you have. So if you're going to use an FHA loan, that will be FHA addendum. All the addendums are pretty much the same. It's just certain verbiage is different in them, but I'm not going to go over all of them because this video will be too long. But I'm just going to talk about this so you can at least know what the addendums look like, some of them. So conventional financing. So date of offer, that's going to be the date of offer. Buyer, that's your name and with someone else if you're buying with someone else, and then the seller's name. The address would go here. And then what type of financing you're doing, whether you're doing a first trust, second trust. So a lot of things are repeated again, but you have to have this because this protects you for your financing contingency. So then the next item is your, let me see, this contract is contingent upon financing, and whether you're going to do this, finance contingencies shall not be applied to any alternate financing. So if you choose another financing, say, well, you had a conventional loan and then you say, oh, well, I'm going to go with the FHA loan. All of the things that are changed with the contract, the seller has to approve it. They have to agree to it. You can't just change it. It's like, oh, well, I don't want that loan. So it's important to know what type of financing you have before we go out to look at houses, because that could be detrimental to you, because if you don't have that financing contingency in place and then you can't close due to financing, then you are in default, and we don't want that. So seller's option to void the contract, buyer shall deliver by 6 p.m. whatever day after date of ratification, financing deadline. a conditional commitment for financing. So this is stating that the lender has committed to lend to you. So if the house is 400,000, the appraisal has come in. So they're saying, well, all these things these are the final items that needs. It shouldn't be a long list of things, but it might be. It should be maybe at the most 3 items on your commitment letter. It shouldn't be a lot, because if it's a lot, that's the problem. I would think that would be an issue. All of those things they probably have to re-verify, but a lot of things they probably would have at that point. But they verified all your income, assets, employment, your credit. They've done all that. So they just have to do a re-verification, make sure you have your job. They've probably already done your verification of employment, but they want to make sure that you still are employed. Because it happens. If you're not employed, then they're not going to give you the house. So removal of a contingency. So I want to talk about this. I usually don't remove the contingency because I just like to have that cushion just in case. Because unless they ask of they, meaning the listing agent, unless the listing agent asks me to remove it, I typically don't. But I always let you know, like, we're getting close to that point where that could happen. So if you feel like something's not going to work out, like, I need to know ahead of time. And so we can talk about that on your initial file. So financing rejection. So the buyer may deliver notice declaring that the contract is void if the buyer receives written rejection for financing. So you have to receive a rejection letter in order to get out based on the financing contingency. That's important. So if your appraisal comes in low, then we have to ask the seller to reduce the price. If it comes in at the appraised price, that's fine. If it comes in above the appraised price, the loan won't be based on the appraised price. It is, but it's, say if the house is 400,000 and the house actually appraised for 410, they're not going to give you a loan for 410. Just so we're clear on that. The only time that would work if it was a USDA loan. All right, so this talks about defaults. This is the whole paragraph, so I would suggest you read paragraph 8 if you're choosing to buy in DC or Montgomery County. And lender required repairs, and then you would sign a date at the bottom. So this is an addendum. So is this addendum of clauses, A. So there is a B also. So let's go through this. So the buyer. So the contract date of sale is dated today, well, whatever date that you're actually submitting the offer, between buyer, which is you, and if you purchase it with someone else, their name is also there, the sellers, the address, the actual lot, where the location of the property, the project name, the tax account number. So paragraph 1, seller credits to the buyer. So it could be an amount or it could be a percentage. Though, if the lender does not allow for any credits, then the credits will be given back to the seller. So that's important to know. So if you have exhausted all your credits, then you can't do that. So say, for instance, if, you ask for seller credits and then, with the home inspection, you ask for other credits, that amount would have to be reduced. The sales price would have to be reduced because you've exhausted all your seller credits, because you don't want to not be able to use the money. So this is where we talk about inspection contingencies. So you want to get an inspection, so that those days will be there and that will be checked, and then you have your right to negotiate. Or you could choose the right to cancel. So it's either or, you choose A or B. And if the property is as is, that will be checked. And radon inspection contingency, that will be there. Let's see. Appraisal contingency, not to be used with FHA and VA, so you have a certain time period to get that done. Holding deposits, so we wouldn't do this because a real estate broker does not hold, my office doesn't. If it's a well and septic, that's there. If you are a licensee, meaning your license, that would be checked here. If you have a real estate license in another state, that would be there. Any additional provisions is there any post-occupancy? So what that means is if the seller would like to remain in the house after settlement, that is a possibility. And that actually might help you win the contract if you are agreeing to that, which we can talk about that. And then you would sign a date. And so the last document I'm going to talk about is the escrow agreement between the buyer-seller and the escrow agent. So because my office does not hold escrow and the title company holds escrow, there has to be an addendum for the, well, it's, I won't say it's an addendum, but it's an agreement. It's an escrow agreement. It's not part of the sales price, but it's part of how they've actually received your funds. So the date between the buyer and seller, the property address, talks about the deposit and the deposit amount, talks about what the actual how the funds will be released. So this is talking about your earnest money deposit. So the release of earnest money can be one of a couple ways. So at settlement, it can be released because everybody has followed all the rules. Well, I want to say follow the rules. I don't want to say that. Followed their executed their part of the contract. I'll say that. So everybody has executed their part of the contract, and we can go to settlement. So that's when the earnest money will be refunded and credited towards your closing side of the transaction. So if you choose to do a mutual release of contract and that agreement has been signed by all parties, the funds will be returned back to you or however it was agreed upon. That or court order. So those are really the only ways that deposit can be released. One party can't say, "Oh, well, I want my money back." Yeah, that won't happen. Everybody has to agree, buyer and seller, because buyer and seller agreed to the contract. So next talks about disputes of holding funds, attorney fees and costs, the entire agreement, and so you would sign. And then this section is the date of deposit receipt. So the escrow agent has to state when they received your deposit. So that's important for the contract. And that is all on the Greater Capital Area Association of Realtors discussing DC and Montgomery County offers. Thank you so much for watching. Until the next time, I'm Rashana Levin with Keller Williams Realty.